Paris, this joint course we can do. So I studied English law and French law. I was quite excited at the opportunities that came to me as a young student. The UK recently joined the European Union, so it gave me opportunities to study abroad and in the European Union. And while I was there, both at King's London and in Paris, I did twice, because I did it in Paris as well as in London. We had a course on EU law, and a small part of that back then was called EEC law, European Economic Community. A small part of that was competition law. And I really liked this area of competition law because, frankly, it seemed to be quite easy. So then there were basically two articles in what was then called the Treaty of Rome. There was Article 85 and Article 86 of the Treaty of Rome, which are now Article 101 and 102 of the Treaty, the TFEU, the Treaty on the Functioning of the European Union. And those rules are essentially the same as the Indian rules that you've been hearing about, that you know about. You can't have anti-competitive agreements, and here's some examples of those, and you can't have use of market power. I think it's important to remember how simple competitional principles are and not get too bogged down in the detail of implementing legislation that will be in different jurisdictions. I'm sometimes jealous of economists because economics change no matter where you are in the world. So competition economists find it very easy to be advising on US antitrust and then Indian competition law, European competition law. Law, you need to work with local laws to know the procedures, the way in which the legislation, the principles are being applied in practice. But one of the great things about my practice, a lot of it is international, so it allows me to work with great lawyers, competition specialists around the world. I prefer to use the word specialist when you talk about competition law rather than experts. The word expert has got a sort of bad connotations in the UK at the moment because people are saying, don't listen to what the experts are saying. Do what's right for Britain, and you don't need to be part of the European Union. And I found myself getting quite frustrated at that because, frankly, it is good to listen to experts. I want you as people embarking on careers with disability, so many of you with dark hair, like I used to have last time I came to Delhi. When you're looking at your future careers, I think it would be a great achievement if you can find it easy to explain to the man on the street why competition law makes sense, why it is good for the people generally. We heard this morning in the inaugural presentations references to how the men up there, all with their grey hair, which means that none of them learned competition law when they were at university, are all, I was really impressed hearing how the guys at the top in implementing competition law at the CCI, at the Appeals Tribunal and the courts as well, understand the basics, that it's all about looking at effects. What's the effect of a particular agreement that you may have on conduct, and seeing whether it is detrimental to consumer welfare. And if you can stick to those basic principles, that's great. You'll be good competition laws going forward. Don't get too stuck in the black letter. Look at what's happening in Europe. The competition rules in Europe date from when they came into force, 1962, which is roughly when I was born, actually, around that sort of time. And they've been interpreted and applied in different ways. When I started doing competition law, concepts like horizontal and vertical agreements people weren't talking about them. They just looked at agreements. It became a gradual process where these concepts of horizontal and vertical seem to make sense. But it's very easy to understand. A horizontal agreement between people at the same level of trade, vertical when they're at different levels. And I found it interesting to look at what's happened in India, where that's been formalised into the legislation. But it doesn't detract from the basic principles which are there. Is the agreement good for and consumer welfare. And then how do you decide whether agreement is good for consumer welfare? Well, market power. There's nothing in the Treaty of Rome about market power. Market power comes into it. The whole of 102, the rules of abuse of dominance, you have to have market power, real market power, dominant position before you even need to worry about it. And there is nothing wrong in India or in Europe or the US in having a dominant position. If you have a dominant position, you have a special responsibility in how you conduct yourself. In Europe, I think it's fair to say, around the time when I started practicing, it got too formalistic. There were all sorts of block exemptions which were there, and you had to spend time working out whether your agreement, if it was a distribution agreement, complied with special rules for distribution agreements. But ultimately, what really mattered was whether there were what we now call hardcore restrictions. So agreements which fix prices between people same level trade, cartels, they're completely bad. Vertical agreements where a supplier imposes resale margins on distributors, says you must sell that price, they're also bad. Why is it bad? Because they'll result in prices being higher than they might otherwise be. And why is that bad? Well, it's going to mean that consumers, people distributors, are going to be paying more for their products. But when you have legislation of that time, it gives those who are enforcing it quite a lot of discretion. And that can, if those who are enforcing the rules don't bear in mind the basic principles of what it's all about, can lead to competition law being misused. The great thing about competition law is the law part about it, because if people are misusing the legislation, then you can take the court ultimately. And one thing I've learned about India is that you love taking people to the court. It's a very litigious society, which I think is great as long as the judges are applying the law in the right way. And how do they know how to apply? Well, they can read textbooks and spend time doing courses. They'll also listen to the applicants who are explaining why their particular client's position is the right one. Same when you're dealing with a competition authority. We've touched briefly on global cartels, and so much of what's going on in the world is now global. There are very few things which, well, in Europe by definition, case is international if the European Commission is looking at it, because they are a supranational authority. Very local cartels the Commission will never look at. That's one reason you're hearing from Mr. Sharma about these daily news splits in Europe. Yeah, I mean, it's more a policy one that the Commission has got limited resources, and so says small deals we're not going to get involved in. And so the market share thresholds are part of saying we won't get involved. But there was criticism from you should leave the national regulators, because in Europe the national competition authorities can also look at legislation. You can't say there's a price fixing agreement between two taxi companies in a city. That's never going to be looked at by the European Union because the players are going to be too small. But that's the sort of thing where you can see why it's going to have a negative effect on consumers looking to cash their taxi in whichever town it might be. In India, we've got the CCI, which, if I understand it, has got jurisdiction from the largest to the smallest transactions. So de minimis concepts, there should be nothing which is too de minimis if it's having a negative impact on consumers that we might take in India. And going back to what I said earlier, market shares can be an important part of that for most agreements, but for cartels, it's into the hardcore area, then even price fixing agreements between people with relatively low shares can have a negative impact on competition. So those are basically my opening remarks. I'm very happy to be reactive and responsive and give insights from a European perspective, because we're talking more about what happens in India. And as I say, I'm really keen to hear from the audience, especially the young people looking to embark on a career. I'm very pleased with the way my career has developed. Part of the excitement was when I was starting, I found that the practitioners were either also young like me, who'd been educated and were influenced by or grey-haired people who had seen this is something I can get into because the basic concepts are relatively easy to get to grips with. And if you're experienced as a lawyer, and you're also well versed in all the procedural issues and the know how to read the local regulation in order to sometimes find loopholes in the legislation until the regulator gets up there. So young people learn from the experience of all the lawyers that are in the room what they need from India, what they need from Europe or anywhere in the world. It's a great profession to get into.
Thank you, Mr. Boyce. What we do now is open the floor. No, that's what I'm saying. We open the floor. Just spend the first 2 minutes to respond to any of the points which the panelists would like to bring in, and then questions and respond. So each of the panelists, if you want to respond to a point which has been made by the panelists, I like to do that, but we'll spend just 3 minutes. 2 3 minutes.
I'll actually respond to what Mr. Boyce said and Dr. Tamara said on the so-called cooperative strategy setting. In fact, I agree with Mr. Boyce that the competition was able to be misused also in a situation where the legislature gives so much of discretion to the authority. There actually have been 2 cases, which I would just like to mention very quickly, about the misuse of the section 3 and 3.4 kind of syndrome. So about the horizontal exchange of information, bona fide exchange of information is, I think, is okay, and European guidelines are very clear. But there was one single case in India so far where a group of companies under an association went to get the anti-dumping duty imposed. They went to the DG safeguard duty, and the side who lost the duty case filed a case in CCI. They say they are cartelizing. So they have exchanged information on their capacities, on their output production, and that was a case of Alkali Manufacturers Association of India. So some of you can see. That was a case of 2013, since I was a counsel for that, so I remember it very clearly. And there is another, the joint venture I would like to add, sir. There was a joint venture between Star and ZTV. Again, it's a grey area I'm trying to touch. The Star TV and the ZTV, they at that time had the largest market shares. So the complaint was that they did come together and they form an aggregator called Media Pro. So they're going to corner the whole market, they're going to lose the dominance, and therefore they're going to increase the prices. So in that case also the Commission went into the economics of it and saw that yes, though there is the industry is so clearly regulated, the telecom industry, that it's just not possible that there will be anti-competitive effect because of the fact that the both had the channels were regulated by TRA specific guidelines. So that was the case I'm just trying to mention, that even the exchange of information can be dangerous, but how it can be dealt with by the regulator, and secondly the joint venture also. And after Dr. Tamara's things, I just like to add, the cooperative standard setting, which you just, I think, hinted upon, is very clearly seen in the case of standard essential patents. So we have already cases going on. The Ericsson case versus the Tex and Micromax case are just that. So the moment these standards are set, a lock-in effect develops. And after lock-in effect, there could be either a patent hold-up, there could be a patent hold-out. So you have standard implementers, you have standard developers. So all those issues are very many, so the time is not there. So I just thought I'd just add those stuff. Thank you very much.
Would you like to say anything on what the other panelists might have said?
If I could add this, I think it's
something wrong. Okay. I think John very nicely answered one of the questions that you had raised earlier in the morning, which is, should there be any de minimis kind of threshold? I know this taxi cabs example. Yes. But also there are certain inbuilt safeguards. In the sense, you have to show that parties have a certain amount of market power, without which there will not be any effective competition. So I don't think there is any need to have these kind of set thresholds under which the Commission should not look at a particular case. It depends on case-to-case basis, perhaps.
Just one point I would like to add. I mean, I talked about horizontal agreements which are pro-competitive, but again, there is a very thin line dividing what is competitive and what is anti-competitive. And while the first step would be to look at the economics of the industry to see why certain practices are being followed, it also is incumbent on the regulator to make sure that in the guise of what is construed as a pro-competitive agreement, the parties are not actually engaging in anti-competitive behavior. So for instance, when you talk about information exchange, what is the right sort of information that can be exchanged? If you're discussing future prices, you're talking about capacity utilization, or discussing very specialized, targeted information, that might not actually be a good thing in terms of competition. But however, if it is publicly available information, it is not strategic, but it's much more broad-based, then that would be okay. So again, the application of MIND starts with identifying the economics of the industry and why those practices are prevalent and whether they make any sense, but also keeping an eye out for whether these agreements are actually being misused.
Yeah, just briefly and sort of picking up on the same sort of theme of information exchange. There are some useful guidelines that the Commission has produced recently in Europe, the horizontal guidelines, which look at various categories. They try and categorize various types of horizontal agreements into agreements which are broadly potentially pro-competitive. And what tends to be the determining factor on whether one of those agreements is pro-competitive are the participants. So you look at information exchange agreements. R&D is an interesting one. So, and I think that's an easy one to illustrate. But if you have two or even 3 or 4 small businesses coming together and developing a new product, which they wouldn't have been able to develop on their own, it actually offers more choice to consumers, and if there are more alternatives to what the larger players may already be developing on their own, then it may help bring down prices as well. But if you have exactly the same type of cooperation and just deleted the names of the small companies who have labeled it and replaced it, there's always a lot of precedence. You take that agreement, just replace the names with the 2 largest players in the industry, and their combined market shares are someone with 30% and someone with 25%. You can see how they're producing something together. They're no longer producing alternatives to the computer, to each other, and also they may make it more difficult for the smaller players' products to come to market. So the principles are basically the same, and the Commission in its horizontal guidelines looks at information exchange agreements, R&D agreements, joint production, joint selling. Because it's sort of in the topics, and I'll just mention it, joint ventures, when you look at them, tend to be quite complicated to categorize. And they don't fall into one of those sorts of categories, so they tend to be looked at on a case-by-case basis, and it's complicated further by the fact that if you have a joint venture, which is what we tend to call full function, doing the production and selling, then it's more likely to be looked at under the merger rules. So I think that's what the same in India as well. Joint ventures is a fascinating area. One area where we did spend some time with the Commission looking at a joint venture which fell short of a merger was in the airline alliances, where there are reasons why airlines can't merge. If Air India were to merge with Lufthansa, it would no longer be able to fly from India because it wouldn't be the foreign ownership rules. That's basically what stops it. So the Commission and regulators around the world are more tolerant in practice from a policy perspective about allowing airlines to cooperate, and that level of cooperation even does joint pricing. And in Europe, the Commission has looked at some of those cases and can use the powers under Article 101 to say we're only going to allow this cooperation if in areas where you've got particularly strong positions, and competitors, make it easier for competitors to compete with you. So that's a good example, I think, of how, for policy reasons, the competition authorities can be more lenient or tougher in particular areas. So it's really important to say in the Commission that those who've got that power are held to rights to make sure that they are still applying the rules with the basic principles and objectives in mind.
So we have completed the first round. Now I think we can get into some discussion. The floor is open. What I would suggest is anyone who has a comment or observation or a question may introduce himself or herself and direct the question to a specific panelist, or if he or she wants more than one panelist to respond to that, please say so. So, yes, please. I think what we'll do is we'll take 3 questions and then direct them to the panelists. So that makes it easier for them.
Yeah, I am Ansuman Patnaik. I work for the DG. I am an additional DG there. My question is to Mr. Boyce, Mr. Kamara. There are certain industries which show what is called consensus price pluralism. The airline industry does that, and the software industry does that. It is not bad. I mean, there is no spoken on evidence of any market. But the prices move together, they fall together also. I mean, internationally, have they been punished anywhere? And my point is, I want to learn something from that. Internationally, whether consensus price pluralism has been seen adversely without any smoking gun evidence.
Yes, please. Yes.
I have a comment and a question. My name is Nadal Joker from Sharda. Abdul touched upon the concept of direct and indirect effects when it comes to cartels, and I think we've raised it in the context of autopaths. When it comes to direct effects, and if 2 companies overseas have cartelized in supply of a product into India, I have sort of no sympathy for that. But when it comes to indirect effects, and I think member here in this morning's session had talked about enforcement priorities, and Dr. Singhvi had talked about the rule of double jeopardy. Given the fact that the resources of the Commission are so stretched, for the Commission and for the Director General's Office to investigate potentially 100 cases of where a part has been supplied overseas and finds its way into an imported car in India, I think is a sort of waste of judicial resources. And especially so when the alleged cartelists have probably already faced action and compensation claims overseas. But my question is, and perhaps if Mr. Sharma could respond to it first, and then Abdul could sort of explain the logic of his position. My question is that the Section 3 of the Competition Act prohibits the entering into of an agreement. Suppose a RFQ was issued prior to the enforcement of the Competition Act, so prior to May 2009, and the cartel participants entered into that agreement prior to May 2009 to rig a bid. Their agreement ends, in a sense, when the bid is awarded to the winner. Now, the question then is that if all of that, entering into the bid, entering into the agreement, the bids being placed, and the contract being awarded, all takes place prior to May 2009, the date the Competition Act came to be, should the Competition Commission have jurisdiction over something like this? And let me just let me give you an example. Suppose there is a bid to build a bridge from point A to point B, and the bids for that were invited prior to May 2009. It was awarded to the winner, say L&T. Prior to 2009, they already started construction. They midway of construction, and someone says that there's a cartel. Is there, firstly, is there legal jurisdiction, and secondly, from a policy perspective, should someone come in and say stop the construction, rebid, and start the whole thing all over again? So, Mr. Sharma, I'd be interested in your views.
1 minute. Anyone else? Yeah.
I'm Siddharth Mehra, I'm a student of business laws in LLM. We were just discussing the de minimis thing yesterday in class, and one of the scholars said that their lecturer had a comment with regard to the Act saying that because de minimis is not available in India, it's a lacuna in the Act. And looking at the comment that has been given by Mr. Boyce saying that it's more of a policy decision due to lack of resources. And in India, like in a smaller jurisdiction, everything should be looked at from an AAC perspective. I would like to get the opinion of the panel on what they feel. Is it that de minimis is, because if you look at it purely from an economic perspective, then yeah, something like de minimis makes sense because business proficiency is there, so if it's not affecting the market too much, let it exist. But giving it a policy perspective and then the view of it changes for me as well, so I get a bit of an explanation.
Yes, can we start with you? The first question that Mr. Patnaik asked.
Yes, so if I understand the first question is looking at conscious price parallelism, yes. In fact, the very first case that I ever did back in, when I qualified in 1987, it was a cartel case. And in those days, we didn't have a leniency regime, so it was quite acceptable and the norm for all the lawyers, for all the parties to get together and agree what the legal arguments would be. That was what we lived in then. It was great. I got to know lots of competition lawyers from around Europe. And one of the arguments that we developed then was, well, yeah, all the prices were moving at the same time, but that's because it's a really competitive market, and it's a perfect market, because everyone responds to meet the prices, and that's why all our prices are the same. We sort of got economists there who explained how this is what works, how it happens in competitive markets. Unfortunately, the Commission had managed to get hold of some documents which showed that the parties had all been at a golf course on the same day and they fixed the prices, so the argument didn't work. And I think another area where you have lots of cases in Europe, often by the national authorities, has been petrol prices. Because if you're traveling around looking to fill up your car with petrol, you quite often find that the prices are very similar. And the authorities sometimes say, oh, there must be a cartel, but the prices are similar. But the truth would be, if someone was charging 10% more compared to someone who was just down the road, people would find out about that, and the guy who's charging 10% more wouldn't be selling any petrol. I think what has really changed things, and this must be the case in India as well, it's certainly the case in the whole leniency regime, and the ability to find documents as well, that if anyone is arguing conscious price parallelism, that is just how competition is working, the Commission will be looking for documents which prove that no, it's because of a cartel. And when you've got the leniency regime in place, then people often, the leniency applicant or the immunity applicant presents the evidence to the Commission on a plate. I'm not sure that answers the question, but that's some practical observations on how it works. So this is where the procedure comes into play rather than the economics, I have to say.
Can I respond to Mr. Patnaik's question and add to what?
I'm sorry. Not sure. Okay. From an economist perspective, price parallelism is not sufficient to show cartels. You know, I mean, in a perfectly competitive market, you will see prices moving up and down together. That doesn't mean that there's a cartel. And, you know, usually in the context of oligopolies, there are theories which talk about oligopolistic dependence, where competitors, they do not talk to each other, but they all respond similarly to the economic conditions. And so to determine a cartel just based on prices is actually a very dangerous thing to do. Because as an economist, you know, we cannot say that a cartel exists or doesn't exist just by looking at prices. And as John pointed out, you need to have the documents which show that there was an agreement, and also infer other types of agreements which you know, could support the analysis of price parallelism. But again, just price parallelism itself is very common in a perfectly competitive market. It's very common in an oligopolistic market. It's just the nature of competition that makes those prices go up and down together, and that is not sufficient evidence of cartelization. And again, I mean, you know, the role of economists in cartel cases in the United States, for instance, and I think starting to be that way in Europe as well, comes in actually when there are damage claims to be estimated, where a cartel is already been established, and the question becomes, what was the damage caused as a result of a cartel? And in order to figure that out, you need some of what, you know, econometric or statistical tools to assess what the counterfactual would be, in the sense, what would be the but-for price, and then estimate damages. So that's really the role we play, but it's not, you know, economists cannot determine whether there is a cartel or not. So from that standpoint, prices do not reveal whether there's a cartel or not, or they are not the only metric by which you judge whether there's a cartel or not.
I would like to first
respond to add to effect what Dr. Tabara said for the benefit of Mr. Patnaik. So I'm sure you must have read this policy brief by OECD, prosecuting cartels without direct evidence. I would request you to go through that. I'll just try to explain a part of it. You see, in addition to what Dr. Tabara said about price parallelism being not the only, or rather not the only indicator of a kind of coordination, there is a test which is generally employed as the action against self-interest. Now this is what actually in some matters we have used successfully before the commission, that they are behavioral models. You know, the circumstantial evidence is actually of two types: a communicative evidence and the economic evidence. And the economic evidence comes the conduct and the behavior. Now I will focus on the behavioral aspect. If the behavior of the firms is something which is actually against its own interest, that actually it should not have done, but it is doing what others are doing, or is it capable, or is it behaving independently of its others, then certainly it will be ruled out. There is a kind of coordination. We call it as a Nash equilibrium in economics. You know, that means that best response to the anticipated best response of your competitors in an oligopoly. So there is an oligopoly. Suppose one of the firms raises the price, I am naturally expected to raise price. This doesn't make it a coordination, because that is what is expected from me. So if it can be proved demonstrably that there is a Nash equilibrium existing in the market, then certainly it is true. The second kind of behavior model is that a mutual accommodation. That well, let us, without actually having an understanding, let us accommodate each other so that everybody gets a benefit. That is also not a cartel. It's only the third type where the firms actually meet, or actually, you know, sort of have an understanding that they want to achieve a particular result which will collectively benefit them. See, that is the point. So parallelism may not benefit everybody, but if it does, certainly it could be indicating towards cartels. That's what my answer to you, sir, is. And if I can try to answer what Naval said, Now, if I understood your question very correctly, is that you're saying that there is an arrangement. I presume it was a cartel-like arrangement. A coordination was made before 2009. But according to you, the agreement actually was reached after 2098. Kindly clarify if you I may understand.
Sure. The conduct took place prior to May 2009.
All right.
The agreement ended prior to May 2009. But under the contract that was awarded pursuant to the agreement, supplies continued for post-May 2009. This is distinguished from the Kingfisher Jet case. In that case, the alliance continued post-May 2009. And therefore, the continuing effects doctrine jurisdiction was extended. But in this case, the entry into and the purpose of that agreement exhausted prior to the act of
I think I would try to answer it like this because there has been a case of this type in CCI, perhaps you are aware already. And since I happened to be the counsel again in that case, exactly the same situation was there. There was an alleged cartel between polyvinyl suppliers to the railways that actually took place much before 2009. It ended before 2009, but the effects were continuing. So the railways actually came up with a reference to the CCI that will we find there is suspicious arrangement between these suppliers. And there were only 3 of them. Suppliers were very limited. So they found there must be an understanding because the number of places is less. But the commission in its wisdom actually closed. So my answer to you is that if the agreement had concluded before 2009, that is before the commencement of the operation of the Act or the Section 3, but if the effects continue beyond that, then certainly it cannot be any ground to prosecuting those parties for a cartel. It just cannot be. Of course, Kingfisher, you yourself have said, if the agreement is continuing, and we have actually finding a case of this type in, in other forums also. There are cases of, which are going on where one particular group of companies is trying to impose a condition which is continuing. So it may have been made before 2009, but the effects are continuing. So in that situation, certainly the Commission can look into it. And that could be the answer for it. Thank you.
Yeah, thanks for your comment and question. I think as far as your comment is concerned, entirely in agreement. There are limited resources and the PG has to, the Commission has to apply those resources at hand to the most important cases. To answer your question, if an RFQ is issued prior to May 2009, supplies have also been completed prior to May 2009, there's nothing left of that agreement. Then, just let me see all the different situations. Then perhaps the Commission has no jurisdiction. If supplies are still continuing, then arguably that agreement is still being given effect to post May 2009. So arguably the Commission may have jurisdiction. Of course, an agreement after May 2009, the Commission will have jurisdiction. Now, like you mentioned, should the Commission actually use its resources, its limited resources, to look at all the innumerable auto part investigations that we have open, possibly not. It should concentrate on those that have direct evidentiary value post May 2009 and leave it at that. Perhaps that's the straightforward answer to your question. I think there was a second example that you gave, but if you could repeat that, or if you're happy with this.
Able to answer his question, give minutes. You mentioned about the minutes.
Sorry, you have to repeat that.
Because basically, we wanted to test, is there a situation where we have the effect of conductors so small that it doesn't really have a market big way? Should you spend your resources, should the regulator spend resources on investigating?
Yeah, I think that's a great question. Sort of covered this. I think so even the Commission has in a couple of cases recognized the de minimis principle and has said that look, the effect of the conduct is so little on the market, it's so small, and these parties in the market share is so small that they need not go into or pass an adverse order against the party. So they've sort of already recognized the de minimis principle in their own. I hope
I was only saying it from the perspective of it's a policy decision versus every anti-competitive practice, irrespective of its effect on market should be taken on. Right? Just that sort of a thing. Because he said, he said that it was people in EU, because it's an international, supranational body, they have a concept of de minimis because if it's a small market, it doesn't affect such a big area. But in a country like India, you should go ahead and prosecute even smaller players because it is an anti-competitive thing. So it's just a comparison with that. I understand.
Can I answer to your question? You see, if I look at section 3 and 3.4, and if I look at the guidelines available in Europe, I think as a student you can look at it like this. Whereas the section 3.3 violations are by object. So the agreement is sufficient. The fact that there is an agreement is sufficient to bring the violation into the law. But this section 3.4 is the effect. So we have summed up the object effect in our section 3.3 and 3.4 according to me. So now coming to your question, if there is an agreement of minor importance, that is a de minimis,